Subscribe to get contents via mail. Purchase shorthand journals and more.
Arguing for the appellant NCB, Mr. Jayant, learned additional Solicitor General, submitted that while passing the impugned order granting bail to the respondent, the High Court has erred in observing that no incriminating material was recovered by the NCB officials at his residence. He stated that the High Court has completely overlooked the fact that it was on the basis of the disclosures made by the respondent himself that huge quantities of narcotic drugs and injections were seized from the godown of the co-accused, who was subsequently arrested by the department, that the High Court has committed a grave error by not applying the terms and conditions imposed under Section 37 of the NDPS Act, that the offence committed by the respondent falls under the category of recovery of commercial quantity of narcotic drugs, and in the light of the embargo placed in Section 37 of the NDPS Act, the respondent ought not to have been admitted to bail, and that this is a case of constructive/conscious possession of the contraband substances, as the respondent was an active participant in a organized gang that was involved in smuggling of drugs. Lastly, it was stated that there was sufficient circumstantial evidence available against the respondent which would disentitle him from being admitted to bail. On the other hand, learned advocate on record appearing for the respondent vehemently opposed the present appeal and submitted that the High Court has rightly admitted the respondent to bail after he remained in custody for a period of 1 year and 3 months. He submitted that the impugned order was passed after granting a hearing to the counsel for the appellant NCB and the respondent has not violated any of the terms and conditions of bail imposed on him. On merits, it was urged that in the alleged incident neither was the consignment of the narcotic drugs booked by or for the respondent. No recovery was made from the respondent, and nothing was found from the search conducted at his residence and shop. Describing the respondent as a small-time shopkeeper selling medicines at Agra, learned counsel submitted that he had no connection with the other co-accused persons, and that his name had cropped up in the course of the statement of the co-accused under Section 67 of the NDPS Act, which was partly recorded at Agra and partly in Delhi, though had taken the officials to the respondent's shop, which was duly searched. Nothing incriminating was recovered from there. Besides the above, both the co-accused and the respondent herein had at the first opportunity retracted from their statements recorded under is inadmissible in the trial of an offence under the said Act, urging that the High Court has followed the aforesaid judicial, and after noting the fact that the charge sheet had already been filed, and besides the confessional statements of the accused recorded under Section 67 of the NDPS Act, no other incriminating material was forthcoming. The respondent had been rightly admitted to bail.